All right, so we will start right now and we'll let everybody to join as we go along. So good evening for people who's in right now and thank you for joining us on time. Today is our second seminar this year, COVID-19 and layoffs and what you need to know about it. Why we thought it's important seminar. Number one, many of you had to lay off, then rehire, and then lay off your staff again. Some of the staff you will eventually rehire and some will not. What we will talk today about is a type of the situation exactly like that and other layoff issues you will be facing. Aaron Rousseau is a partner in Rousseau Mazuka firm. He is with us. He will take us through the presentation and give us all the insights. At the end of the presentation, you will have the opportunity to ask the questions which you may come up while listening to it. To ask the questions, in the right top corner, you will see an icon right beside the little people, then chat, and then it's a triangular square and a circle right beside the hours, beside the time. By clicking on it, then clicking on questions and answers, you can ask any questions you like to ask Aaron. We will be monitoring the questions and he will answer them at the end of the presentation. Aaron, it's all yours.
Thanks very much, Eugene. I appreciate that. Thanks everybody for tuning in. This is a topic that's got a lot of importance, and there's often a fair bit riding on it. In many cases, people's businesses are very much on a knife edge here, and it's important to get these issues correct. The learning objectives that we're going to hope to hit today are understanding what the time limits are around the special rules that pertain to COVID-19, what the time limits are generally when it comes to layoffs, who those rules apply to, who they don't apply to, whether and to what extent the layoffs may need to be tied directly to COVID-19, how employers can and should go about recalling people on layoff, and some of the risks that can come with messing up, and some of the best strategies for protecting yourself. In terms of my own background, I'm an employment lawyer, so I deal with employment law issues all day, every day, sometimes including on the weekend. And I've been doing that for 14 years. The youthful picture on at the side there perhaps is no longer current. Certainly, it's not in keeping with my COVID hair that so many of us have these days. I do work on both sides of the table, so I deal with individuals as well as dealing with employers, and that gives me a good insight into some of the things that are going through the heads of employees, and I'm able to understand that situation. And that gives some helpful practical insights. And then also, frankly, in addition to being a lawyer, I run a business myself. The law firm is a business and have about a dozen employees. So I do have a very much a hands-on understanding of how some of these issues play out. Today, we're focusing on employers. Standard disclaimer, this is, I'm going to give you information that hopefully is going to be helpful. Not actually giving a legal opinion in this webinar. So if you want specific legal advice, absolutely talk to a lawyer. But don't worry, what I'm saying is right. Okay. So let's begin with what are we talking about when we're talking about layoffs? The layoffs that we're talking about here, and that word is used in various ways, the layoffs we're talking about here are layoffs that are temporary. You say to an employee, I can't keep you around just now. We're going to go on layoff. Maybe you know that you're going to bring them back in 3 months. Maybe you don't know when you're going to be able to bring them back. But the idea is that things are temporary. You're not saying, unfortunately, we can't use you again ever. This is the end of the relationship. Instead, you're saying, not right now. You are, go home, but make sure we have your contact information. When things pick up again, we'll reach out to you. That's the kind of layoff that we're talking about. A layoff also doesn't just mean going all the way to zero. So it also includes a significant reduction in somebody's hours. So if somebody regularly was coming in 5 days a week and doing 7 or 8 hours a day, and now they're only in 3 days a week, or they're in 5 days a week, but they're only in for the mornings, that counts for the purposes of the discussion today as a layoff as well. So it's not strictly going all the way to 0 hours, it's also a major reduction. So with that out of the way, I want to talk about two ways which exist in the law to think about layoffs and to deal with layoffs. And those trip over themselves sometimes, and it's difficult to keep them straight for any real people, employment lawyers accepted. So I'm going to talk mostly today about the Employment Standards Act. The Employment Standards Act applies to pretty much everybody. It's enforced by the Ministry of Labor, and it doesn't matter that much what's in anybody's contract. These are the rules for everybody. The common law, or what might be called contract law, is in many cases the opposite. So that's the law that's enforced by the courts, and there the focus is on the contract. Contract is central to that. So I'm going to talk in the first part about the Employment Standards Act, and that's most of what I'm going to talk about. But I'm also going to talk about strategies for how to deal with some of the things that come up in the common law, where that's going to be different from the Employment Standards Act, and how to deal with that. Okay, with one more introduction really before we get to the meat of things. And that's one restriction on the Employment Standards Act, which is that it applies to provincially regulated businesses and other organizations. So almost every business, almost every employer is actually provincially regulated. It doesn't matter if you're a Ontario Business Corporations Act company or a Canada Business Corporations Act company. The question is, what is your area of business? What do you do? So by default, everything is provincial. There's only a handful of exceptions. The most common ones are banks. Guessing we probably don't have Royal Bank on here. Telecommunications. Guessing we don't have Rogers and Bell on this call. The one that comes up most often for smaller companies is just around interprovincial or also international transportation, which tends to come up with trucking, things like that. But almost everybody is provincial, and that's what we're going to be talking about today. And it doesn't, again, it's not only businesses that this applies to. It also applies to nonprofit, to charities, and to all other employers, generally speaking. Okay. So the traditional approach and it's still the law as well under the ESA, is the employer is allowed to lay off an employee on a temporary basis. They're allowed to do that for a limited period of time with no justification or explanation. That period of time is 13 weeks or 3 months. If the employer has a benefits plan or something like a pension plan, or if it has a less common these days, a supplementary unemployment benefit plan, and it continues to make the benefit contributions, then the layoff can be much longer. It can be 35 weeks, which is then pushing to 8 months. So that ends up being reasonably lengthy. At the end of whether it's 13 weeks or 35 weeks, then the person is deemed to have been terminated. And we'll talk a little bit about what kicks in at the end of that. It's also possible, and this has been the case again for many years, that those weeks, 13 weeks, for example, do not need to be consecutive. So if you start, January 27th, but then you bring somebody back in February, but then you send them off again in March, eventually it will kick in. So it's 13 weeks out of any 20 weeks is the rule there, and 35 weeks out of any 52 weeks if you're doing the benefits continuation or whatever else you're continuing that brings you into the 35 weeks. That's still the law. And what I'm about to talk about now is something that's an addition on top of that. So what happened back in 2020 is the government introduced a concept called infectious disease emergency leave, which is a really long-winded and very confusing concept. Infectious disease emergency leave began as very similar to what the name suggests, a leave that people are entitled to if they're sick with COVID, if they need to quarantine, if they are caring for a child when the school or daycare is closed, that sort of thing. And very confusingly, it is still the name for that leave. However, it's also something else. Infectious disease emergency leave, which I'm going to call IDEL, is also something that the government has said applies to layoffs, and it's confusing. But right now, what you can do as an employer is you can put somebody on a layoff if they're not going to be performing their duties or if their hours are being reduced, and it's for reasons related to COVID-19. We'll talk about that. Then the employee is considered to be on IDEL. So they are, even though the employee did not ask for it, the employee may not want it, they're still considered to be on that leave. They don't need to be paid, and it lasts potentially for quite a long time. This presently goes back, and it was made retroactive, goes backwards to March the 1st, 2020, and it presently goes forwards until July 3rd, 2021. Nobody knows when this is really going to end, however, because IDEL has actually been extended twice already. So if you laid somebody off and said, "Look, we'll see if things pick up, but right now they're very quiet," and that was in April of 2020, that person is still considered to be, and has for this entire 8 months, 9 months, is on the IDEL. So you haven't yet dipped into the 13 or 35 weeks. So that's quite significant, quite considerable. In a very confusing wrinkle, if the person was placed on layoff before May 29th, 2020, the employer does not need to continue the benefits for that person to be on IDEL. However, if they were placed on layoff after May 29th, 2020, June, July, etc., then the benefits do need to be continued. That is something which I readily agree makes absolutely no sense. It has to do with when the government brought this in. They brought it in May 29th, and they made it retroactive at that point. So that's, if you are curious about why that bizarre quirk exists, that's why it exists, but it's there. It is completely possible to have somebody go on infectious disease emergency leave, to come off it, come back to work for a while, and then go back on the leave again. You can go back and forth as many times as you like. There's no restriction about that. There's also no restrictions within the Act itself, the ESA itself, about how long any particular stretch needs to be. Though if there's no agreement, then it's supposed to be in at least a whole week. But nothing says it needs to be at least 2 weeks or at least a month, or that you can't bring somebody back for 1 day and then have them go back on the leave again. It's a very open-ended leave, and it's a very powerful tool for employers. With good reason, because obviously things are bad out there. Okay. One of the issues that's out there is that IDEL needs to be for reasons related to COVID-19. So that is a very broad concept. There's been no further guidance on what that means. Two very common things. If there's a business slowdown, just there's less work to do, you need fewer workers overall, or maybe you need no workers overall, the business is closed. That's absolutely, the presumption would be that that's related to COVID-19. It is, of course, possible that a business might have a slowdown completely unrelated to COVID-19. It's possible that COVID wasn't a problem at all, and then, you know what, you got into the summer and there was some unrelated problem. Maybe there was a fire at the office, or there's all kinds of potential things that are not related to COVID-19. But realistically, there's not really any inquiry into that's going on. If the employer says it's related to COVID, then it's presumed to be related to COVID. The other kind, just a moment. The other kind of layoff that might be related to COVID-19 is not a slowdown necessarily, but a change in the way the business operates. So, you might have somebody who was there, in dealing with customers in person, and that role you don't need anymore, but you do need actually just as much or more in a different role, doing remote support or something like that. That would be a change in the operations, and the people who used to be customer facing in person Those people may well be laid off for reasons related to COVID-19, even though the business isn't actually slowed down at all. One thing that's important to understand in all of this, and this is part of the challenge of Canada, where we have a federal government, a provincial government, a municipal government, is that none of this has anything to do with CERB or the Canada Recovery Benefit, nor does it have anything to do with employment insurance. So it doesn't matter whether or not the employee is eligible for EI or for CERB or CRB. It doesn't matter when those things might run out. This is its own world, and it exists on its own terms. With that said, as much as I talked about very big and broad discretion, there are a few things where you're going to go offside on IDEL. So the three that are out there that are significant is, first one, if you bring somebody in to do the job, somebody new, to do the job that you laid somebody off for, that's going to be a problem. If you're just reassigning, people who might have been doing one role before, and now, you know what, you lay off one person and you shift people around, that's probably okay. But if you lay off, Frank, and you hire a brand new person, Sally, to do Frank's job, or used to be Frank's job, that's going to look a whole lot like Frank is not laid off for reasons relating to COVID-19, that it's something else, like you don't like Frank, or Sally's cheaper, or something like that. So that's going to run into problems if Frank finds out. Second thing that's going to run afoul is if you announce in writing, especially, that this is not related to COVID-19. So if you don't say anything, then the assumption is going to be that this is probably COVID-19. But if you certainly say, Frank, you just, I'm unhappy with your performance, and while the office is in this difficult spot, I'm just not in a position to give you, a further chance. That's going to sound like it's not related to COVID-19. So just say, if you're just saying the office is slow, you're going to be safe. The third one, and this is very important, is a permanent termination. So as I said at the beginning, we're just talking about temporary situations. We're not talking about a permanent termination. So that's the third one. That's certainly going to be highly problematic. Is if you say that somebody's employment is finished forever, you're terminated, you're never coming back. That's not going to bring you within IDEL. And one of the important things to consider is you can't give somebody advance working notice of termination and also put them on IDEL. So if you say, okay, Frank, today is January 27th. We have decided, that in June, June 27th, 5 months from now, that will be the end of your employment. And by the way, we're placing you, on this IDEL. That's not going to hold up because you've already given the notice. If you give any type of notice of permanent termination, then you're taking yourself outside of IDEL. Okay. All of this sounds well and good, but someday it's doubtless going to be over. What happens with that someday? So If IDEL ends July the 3rd, as it's presently scheduled to, then at that point, the employees will then start to run into the old temporary layoff provision. So you've got 13 weeks, or maybe if you're maintaining benefits, 35 weeks, okay? I should say, by the way, if you don't have a benefits plan to begin with, then you don't need to maintain anybody's benefits on IDEL. It's just a matter of not turning them off. Okay, but that aside, IDEL is over. Let's imagine it's probably going to be extended, but if it's over in July, then you still are going to have another 13 weeks at the end of that when the employee can be on the regular old layoff, the one that existed before COVID. So that will take you August, September, October, okay, 3 months. So certainly keep that runway in mind. Obviously, if it's 35 weeks, it's going to last that much longer. One of the concerns that some people have with IDEL is that it's a leave, and if most leaves, all leaves technically, under the Employment Standards Act, are supposed to be job protected. So that means that if an employee takes a leave, then when that leave is over, they're supposed to be put back into their job unless it's for reasons completely unrelated to their leave. Sorry, that department shut down while you were away, or we found out you were stealing while you were away. Outside that's the classic leave situation, but that's the leave situation when the employee has initiated the leave. So let's think if it's a maternity leave, or even if it's an infectious disease emergency leave that the employee initiated because they were sick or they were quarantining. At the end of that aspect of a leave, then yes, there's certainly an obligation on the employer to reinstate the employee into their position, or let them return to work. In the context where the employer has initiated the leave, that's not really a concern. They were only deemed to be on the leave, and they're obviously not going to be terminated simply because they were put on the leave. You'd have to really say out loud that that's what you were doing. I'm letting you go because you haven't been around here for the last year and we've made a bunch of changes and now you're not up to speed. That might actually run afoul of the job protection, but pretty much anything else would not. What happens when we get to the end of the 13 weeks or the 35 weeks at the end of the IDEL? Under the Employment Standards Act, the employees are entitled to termination pay, and they may be entitled to severance pay. Termination pay, it's a little more complicated, but it's approximately 1 week per year, up to a maximum of 8 weeks. Severance pay, similar, but it only kicks in if it's a relatively large employer, and if the employee's already been there for some time, but that also adds a week per year. And it can run up to 26 weeks. So you can have a combination of up to 34. So that's out there at the end, and that doesn't go away unless some of the strategies I'm going to talk about can be implemented. And the length of employment, understand, does include the IDEL period. So if you were confident that you were going to let somebody go, you may want to not place them on the IDEL, because that means they'll have been with you for that much longer, and they may turn over from, say, 4 weeks to 5 weeks, or even to 6 weeks, or they might cross the threshold for severance pay. So that's an issue to keep in mind, but it's a rare issue. what I would recommend is at the end of the period, the end of the IDEL or the end of the additional 13 weeks after that, send a recall notice to the employees. If they come in and maybe you're not planning to have them continue to work, no problem. You can give them a termination notice right then and there. Okay, I just wanted to do it in person. But let's recognize that a lot of employees are going to have found another job, they're going to have moved away, something may well have happened, so they're just not in a position to come back, even though they get a recall notice. In that situation, that's great from the employer's perspective, because then you do not need to pay termination pay and severance pay. So if you are in a situation where, okay, people were on IDEL, and then I had them on the regular layoff, but unfortunately the business has not recovered. But they are, so there's a lot of them who are never going to come back, but there is still a business that exists at some level. Then consider giving them a recall notice, and if they don't come back in response to the recall notice, then you've got some savings there, as opposed to assuming that you had to pay them the termination and or severance pay. I would say do this maybe with a week or two of notice in terms of the recall, and it's a way, if they don't respond, ideally follow it up with a second notice confirming that they've abandoned the job. You may just want to count your blessings and file a record of employment. That's a strategy. Okay. Who does this not apply to? As I said at the beginning, it does not apply to employees in the federal jurisdiction. It also does not apply to independent contractors. So if you have been treating somebody, they send you invoices every month or every few weeks for their time, then it's probably not applicable to them either. So you can't use the IDEL in that scenario. Hopefully, your independent contractor agreement deals with what happens on termination, but you don't get the automatic right to interrupt it for a whole long period of time. The third area of concern is employees who've got potentially a significant common law right. And that's the last area we're going to discuss here. So employees can have a contract of employment which provides for a greater right or benefit than the Employment Standards Act. And in fact, literally most employees do in certain respects, just like most employees get more than minimum wage. The fact that there's a minimum wage under the ESA doesn't get in the way of the higher one that they have negotiated and is part of their contract. At common law, a layoff is a constructive dismissal unless the contract permits it. So the way it works is this: if you give a layoff notice to an employee and there's no provision in a contract that says that you can do that, the Employment Standards Act may not make an issue of it, but that employee still has a claim under their contract. And the employee is allowed to say, you can't do that. This is a major change to my employment, and it's one that I do not agree to. If you insist on laying me off, that is the same as terminating me, and I'm entitled to whatever I would get if you terminated me. I don't need to wait for the end of IDEL. I don't need to wait for the end of 13 weeks. That has been the law for a long time. There's a bunch of limitations on that. When can we tell when we're in that situation? The contract may simply provide for the right for the employer to do a layoff. And that can be a specific clause in the contract that just says the employer is allowed to temporarily lay off the employee in accordance with the Employment Standards Act. And that's the easiest way to do it. You can also get there if you've laid the employee off in the past. It could have been years ago, but as long as it's the same job or a similar job, then that practice is a part of even though it's not part of the written contract, it's a part of the contractual relationship. So past practice can get you there. And that's going to mean, presumably, that you can use IDEL. Now, some people have asked, does IDEL change that traditional common law position that you can't lay an employee off unless their contract says you can? The short answer is nobody knows. Maybe. But you don't want to be the case where you find out. So that risk is there. My own view, I think that probably IDEL does not change the common law, and those same rights that employees have are still there. Who do we have to worry about? Who do employers have to worry about in this situation? We need to worry about employees who have been there for a long time, maybe 10 years or more, employees who are older, maybe in their mid-50s or later. We need to worry about managers, and we need to worry about high-income earners. Especially, we need to worry if all of those things are present. That's because these employees are entitled to a longer notice period under the common law most of the time. And realistically, it will typically take them a lot longer to find another job. So for these people, it's potentially worthwhile to go to court and to have this fight and to wait for all the time that a court case can take to wend its way through the system. It's a more difficult thing to do. It requires research. It tends to require help from a lawyer. But if all of those factors align, you can be looking at a very long notice period, something on the order of 24 months, 2 years, which obviously becomes a very significant cost for the employer. So we don't want to find ourselves in that situation. If you don't have an existing contract that permits this, what can we do to take advantage of some of these powers under the Employment Standards Act? How can we get ourselves there? We can get there by modifying the contract, and we can do that in two ways. On the one hand, we can just propose a revised written agreement. There are some technicalities. To make sure it's enforceable, the employee should receive something new, even if it's a small bonus. That's a way of getting yourself that right. Definitely consult with a lawyer if you want to do that one. The other one is you can get the practice adopted of allowing for layoffs. And the way to do that is to start with a pretty short layoff, maybe a week or two. And then once you have established that that's a practice, then you've got the ability to use a much longer layoff. And probably the employee's not going to attack it on the basis of it being just a week or two, as opposed to 3 months. So that's the other way that you maybe can get there. Okay, let me see now. I'm operating in a bit of a vacuum here. I'm going to see if there's any questions. Okay. So I do see there's a question here about maternity leave. So what happens if there's an employee who's on a maternity leave? So they're already on one type of leave. How does IDEL affect this? we get into a tricky situation. You want to be careful that you're not discriminating against the employee on the basis of the maternity leave. So what I would say in that kind of a situation is you don't need to rehire the employee if or recall the employee on maternity leave if there are other employees who have been placed on a leave, or they're not at work because the business is slow, or for whatever other reason, the operational change. So if you've already got some people similar to the employee on a leave, you're probably safe. If you don't, it's a little more dangerous. So there's a little more risk, but you should look at, can I make a case that now my business is slow. Maybe if you're qualifying for the emergency wage subsidy or something else. Look at what you have that you can point to say, this is how I'm making this decision that is not related to the maternity leave. It's it would have happened whether or not the employee was on a leave, unrelated to them, their specifics. So that's fine. I don't know if there's other questions. The chat is or that function is open. Eugene, I don't know if you've got something else you want to post. Maybe I did too good of a job with the presentation. Always a risk. Should leave something out. But anybody,
you always provide a lot of information, and I didn't really come up with anything else.
Hello?
Hi.
Oh, hi. My name is Kate. I was on the call. I didn't figure it out how to text my question. Can I ask now?
By all means, go ahead.
So I have an employee that I lay off in March when the pandemic just started. And actually, she was about a week before I actually wanted terminated her permanently for the cause of her not meeting the sales numbers. So we were doing it all in a big rush, as you know, in March, and she still remains on a layoff. I'm not sure if she is on this IDEL, because in March we just, issued ROEs and sent them to collect CERB or EI, whichever they were entitled to. So my question is, do I need to wait until July the 23rd or so, or can I proceed now?
So the employee generally, based on what you've said, would be on IDEL. IDEL is automatic if they're not performing their duties because of reasons related to COVID-19. You don't have to wait if you've made the decision to terminate, but it's worth considering whether you should wait. Just because if you wait and you give a recall notice, she may not come back, and then you don't need to pay. The downside to waiting is that if you do in the end, you terminate because she doesn't want to come back, because she does say she's willing to come back, then she's got a little bit more service. So you might end up paying an extra week in that scenario. So
Right.
maybe pay an extra week, but on the other hand, maybe pay nothing at all. So that's sometimes you may be able to look at their LinkedIn. You may be able to look to speak to some others who might know if they found something else, or if their life has changed in some way, they moved away. That's a consideration.
Mm-hmm. Okay, thank you.
You're welcome.
I have a question.
Please go ahead.
I'm not sure if you can answer that question, but I will ask. I'm president of the board of co-ownership, and we have only one employee. It's our superintendent. Part of his contract payment of his salary, it's we're providing an apartment where which is he is occupying.
Mm-hmm.
We're about to terminate him. And due to COVID, we know that there is a problem with getting rid of tenants. Is he considered as a tenant after we terminate him? He has 1 week as per his contract to leave the apartment. What are steps?
Yeah, so there is actually at the present time there's no eviction moratorium. Otherwise, you would have a big problem. So normally, what happens in superintendent cases is you're able to terminate. Realistically, the superintendents often do not leave right away, and you need to make an application to the landlord and tenant board and get an order. And then sometimes you even need to have that enforced by the sheriff. So none of that's really changed by COVID. There was an eviction moratorium, but it's no longer in place. But beware, because it might come back, and then you will be in a difficult spot because you won't have a unit to give to some other new superintendent. So it's a very challenging situation. I have come across before in working for other co-ownerships, but it's right now you're in the regular situation, but I make no promises that the government won't say no more evictions for anyone. It's very hard to predict.
Thank you. Thank you.
I think that is it. And I want to thank Aaron for a very informative presentation you have done for us again. Thank you so much, and we will see you maybe sometime in the future again.
Thanks very much. It was quite enjoyable. Thank you, everyone.